I would like to ask the Minister for Policy and Reform when the island's current EU data protection adequacy rating will expire and when the EU will begin the process of renewing it.
Call on the Minister for Policy and Reform to reply.
Thank you very much, Mr Deputy President. The current adequacy rating will not expire as such, but the European Commission has indicated that the current adequacy decisions will be reviewed within 4 years.
Supplementary question, Mr Hooper.
Thank you, Mr Deputy President. I'd like to thank the Minister for that unusually precise answer. Obviously, the Minister is aware that the existing adequacy will be grandfathered into the new GDPR regulations when they finally come forward. But can I just ask how he reconciles his original comments about GDPR needing to be in by the 25th of May and all the pressure that seems to be being put on this Honourable Court and another place to pass legislation quickly, when actually he's just admitted himself that the decision, the adequacy itself, isn't really at risk and it will be reviewed within the next 4 years?
Minister to reply.
Thank you very much, Mr Deputy President, and the Honourable Questioner is obviously slightly confused in this matter, but it does raise two very important but slightly separate points. One point is the adequacy decision and what data controllers and data processors can expect in coming months and years, and the other question is about the good faith commitment that the Isle of Man, Jersey, Guernsey and other places have made to themselves and to others to have in place GDPR equivalent legislation by the 25th or 26th of May. So there are two deadlines, there are two timescales, as clearly laid out by people like the Commission themselves in their communication from the Commission to the European Parliament and the Council, stronger protection, new opportunities, Commission guidance on the direct application of the Central Data Protection Regulation as of 25th of May 2018, COM 2018-043 final, which I'm sure the Honourable Member from Ramsey has read and will be quoting from in a moment.
Supplementary question, Mr Hooper.
Thank you, Mr Deputy President. I'm very glad the Minister has explained that in the way he did. I just want to be clear then. The 26th of May deadline is a self-imposed deadline. It's not a deadline that's been imposed on us by the European Commission.
Minister to reply.
The Commission has always stated, as has the Information Commissioner and politicians, that the vast majority of controllers and processors, provided that they are already in compliance with the existing EU data protection laws, in our case Data Protection Act 2002, will not need to make major changes to their data processing operations to comply with the regulation. So that's always been the clear position. This is not about worrying people unnecessarily, it's about doing the right thing in terms of legislation, secondary and primary. It's about doing the right thing at every organisation, especially big public organisations like government, to make sure that we are compliant with the obligations that we're imposing. We have had imposed on ourselves in the past and will continue to have imposed on ourselves in the new regime. We're doing the right thing to make sure that the Information Commissioner is adequately resourced with the right capacity to fulfil the role equally between all the different bodies affected. That's what matters by the 25th, 26th of May. Now and thereafter comes in the compliance in the interests of people, businesses, in fact of the Isle of Man more generally.
Thank you, Mr Deputy President. So the Minister has just confirmed then that by the 26th of May, as long as people are compliant with existing legislation, that will be absolutely fine. So from a business and an operational perspective, there is no rush to get legislation in by the 26th. I would appreciate an answer to my last question, which is, was the 26th of May, for legislative purposes, a self-imposed deadline?
Minister to reply.
Thank you very much, Mr Deputy President. No, it wasn't, and I'm looking forward to publishing by the end of this week new version, a revised, amended version of the regulations and orders to bring into place the GDPR regulations, which will be published as a second consultation response. I welcomed at the time the 50+ detailed responses we had from advocates, members, businesses, people, civil rights campaigners to the first version, made quite a lot of substantial policy developments. For the second version, which will be published by the end of this week on the consult.gov.im website, and I hope and expect that I will be bringing to Tynwald those same orders plus or minus a few amendments that arise from the second publication of these regulations on the consult.gov.im to Tynwald for May, and I really do hope that this court will be putting in place the orders and the regulations deriving from the data protection bill, which I'm absolutely delighted the branches of Tynwald Court have taken through in a timely, timely, sorry.
Supplementary question, Mr Hooper.
Thank you, Mr Deputy President. So the Minister has just confirmed the 26th of May was not a self-imposed deadline. Can you please advise who imposed this deadline on us by which we had to have our legislation in place and working? And if you will share a copy of whatever document, communication it was that imposed that deadline on the Isle of Man.
Minister to reply.
Thank you very much, Mr President. Politics doesn't work like that. Politics, sometimes things are not exactly clear. Sometimes there's things that you do because it's better to do them. Sometimes you do because you can do them. And what I said clearly in my initial answer is that the current adequacy rating will not expire as such, but the European Commission has indicated that the current adequacy decisions will be reviewed within 4 years. Canada, New Zealand, where else? Various other countries also have adequacy decisions. There's a detailed work programme going on between information commissioners. Our officers are visiting officers in Brussels. We set it on ourselves quite clearly in the programme for government that was endorsed unanimously in this honourable court in memory January 2017 that we would be bringing legislation, primary and secondary, to have the GDPR equivalent legislation in force by May 2018, and we've met that deadline, and I hope and I'm proud, I will be proud of that if it happens in May, Tynwald. So it's self-imposed in that sense, but perhaps there would have been alternatives, but politics is not that simple, and I think we'll be in a lot better place if this honourable court can show that we've taken it very seriously. We've published unusually regulations and orders, 300 pages of them, 4 months before they came to this honourable court for approval. We got over 50 detailed responses, which we've worked through. This is like a marathon, and at the end of every marathon there are some poor runners who keel over because they went too fast at the beginning, and there are some runners who come through gloriously to win at the end. And I've got the feeling that where we are with GDPR is we're coming in, overtaking those stragglers who went off too quickly, and we're actually going to have very, very good GDPR regulation in this honourable court in May. And we'll be even more confident about that if by the end of this week we've published orders and regulations, and then the legal community, the business community, the civil rights community, and anybody else who wants to be involved can properly engage with those regulations in the 2 or 3 weeks thereafter before we come to the debate in May, Tynwald.